Hello Internet, this is Hamilton Law, and we need to talk about this crazy memo that USCIS dropped a couple of weeks ago. I'm sure a lot of you have already heard of this nonsense and are rightfully freaking out. Let me tell you why I think this memo is a lot to do about nothing. First, what does it even mean? There are two ways to file for residency. The first is called adjustment of status. This is for somebody who is here in the United States and files an adjustment of status to USCIS. The second method is someone who is outside of the United States or will travel outside of the United States to process their residency at an embassy or consulate abroad. We refer to this as consular processing. Just so you know, this is what my wife and I did way back in the day over 20 years ago in Argentina. What the memo purports to say is that adjustment of status should be a matter of discretion and administrative grace, meaning it's something special only for unique circumstances. The purpose here is to try and force everybody to consular process rather than adjust status. Now, why would they even bother to do this? Well, one, it's just a straight up deterrent. Consular processing takes way longer, and so this would hopefully deter people from filing. Also, and this is maybe more important, when you file anything with USCIS, you can appeal a negative decision. You can fight them administratively, and you can even sue them in federal court. But it's a long-standing Supreme Court precedent that consular decisions are non-reviewable. So they're pushing you from a reviewable court to a non-reviewable court, meaning they could just deny everyone carte blanche, and there's nothing you can do about it. Now, here's why this memo is largely stupid. First and foremost, I don't know if you all remember, but during Trump 1.0, they dropped a lot of memos like this just out of the blue. Luckily for us, the Trump administration had never heard of the Administrative Procedures Act. That lays out the process for agencies to issue new rules. And because the Trump administration didn't follow it at all, or sometimes followed it half-heartedly, basically every time they tried something like this in Trump 1.0, it got struck down and struck down hard by the courts. Just an example. I think it was in 2020 where overnight they just announced that all of the prevailing wage rates would be going up significantly. Everybody freaked out because employers that were filing extensions or cases right at that time were now facing the possibility of having to pay that same employee almost double to what they were making. The Trump administration was sued, and of course, they lost, and the rule was tossed out because they hadn't fully followed the APA and they didn't fall under one of the exemptions. The exemption was for extreme circumstances. The problem was they were citing COVID, but this rule came out in October, and of course, COVID started in March, and the judge kind of laughed it off as like, what are you talking about? This is clearly not an emergency. In Trump 2.0, they had clearly learned their lesson. And so we had seen them actually go through the process. For example, the H-1B lottery rule that changed it from a straight lottery to a wage-based lottery. That went through the proper APA process, and the rule stuck. So we had thought that the Trump administration learned their lesson until this memo dropped out of the blue. Now let's talk about why the memo itself is kind of ridiculous. And the one thing I want to point out to you here is just on the first page alone, look at all of the citations from a case from 1976 and a case from 1997. And then they cite a Sixth Circuit case from 1968. This is really important because most of the case law that they are citing to from the 60s and 70s was superseded by an immigration law passed in 1996. Here's something I wrote in a recent blog post that's not unique to me. Many attorneys arrived at the exact same conclusion. And here it is. There is a reason the memo leans on pre-1980 case law. It does not reflect current law. We refer to it as IRA, passed in 1996, which fundamentally reshaped this landscape. So quoting congressional intent from the 1970s to interpret a statutory scheme that Congress overhauled in 1996 is exactly the kind of error a first-year law student gets flagged for. When you look up a case that you think supports your position, the first thing you need to do is see if that case has subsequently been overruled. So this is not the first time we've caught USCIS citing to law that either doesn't apply to the case at hand or was overridden. But more importantly, and the second reason that this will be struck down, as we discussed earlier, they completely ignored the Administrative Procedures Act and the processes therein. They didn't go through a notice and comment period or any of that. They just dropped this on us. And this is almost certainly going to get multiple APA challenges, and the courts are going to toss it out on procedure without even getting the substance like they did multiple times in Trump 1.0. And the third point to make here is it seems like USCIS has pulled it back a little bit. They had some later statements where they're sort of emphasizing that, oh, well, this is discretionary, this is discretionary. And it seems like they're trying to avoid a judicial challenge by saying, well, this is not mandatory but discretionary. And if it is truly discretionary, I think we're going to see a lot of officers just flat out ignore it, right? Because they don't want to deal with all the extra paperwork and requests for evidence. Where we may see them try to force officers to implement it is for people that have unlawful entries, overstays, criminal issues, and really trying to push them towards consular processing because, again, they can be denied and then they have no legal recourse. If you're worried about this potentially impacting you right now before there's like a judicial system tossing it out, there is a way to respond to these type of requests. So if you see here, attorneys have already shared some of the requests for evidence they have received related to this issue. And there are positive factors that you can argue to overcome a potential challenge. So you can kind of see where if someone is actually here working on an employment-based visa, they'd have a pretty strong argument. And I just don't think officers are going to bother to potentially enforce this. I think is going to be, again, people that have unlawful entries, overstays, criminal history. This memo is concerning. Right? Because if they were to actually implement it, it could potentially hurt tens of thousands of people, right? Into longer processes, more costly processes, and then a higher likelihood of denial with no recourse. But practically speaking, I think there's hope. And that is because this memo is unlikely to survive any legal challenges. Now, I could be wrong, but let's wait and see. Anyway, if you have any questions or comments, let me know, and stay tuned for more immigration news from Hamilton Law.